Hello, this is Matt on the Moon Family Sedan channel. Will a ripple test replace the Howey test? Well, it's not exactly the craziest idea out there. I'm not necessarily convinced that such a thing will occur, but that's just because I don't think it's particularly likely that we end up seeing what is now the SEC v. Ripple case rise to the level where it's being considered by the Supreme Court of the United States. I don't think that's probable. It could totally happen. I just don't think that's the most likely outcome here. But if it does, I'll just note, as Ripple's chief legal officer, Stuart Alderati, has pointed out, track record's not so hot for the SEC when it comes to Supreme Court cases, having lost 4 of the last 5 that rose to that level. But if we do, even Stuart Alderati said back in the day, I'll show you the quote a little bit later in the video, but even Stuart Alderati believes that it's very possible we could end up with a Ripple test, effectively replacing or adding to, what is known as the Howey test. So there are a couple ways you could question this. Will the Ripple test, if it ever exists, will it replace Howey, or if the Ripple test exists, is it in addition to Howey? Both perfectly reasonable topics for consideration. And what got me talking about this today is there was a thread written by XRP community member Stefan Huber, in which he says effectively, and I'm going to not put words in his mouth, I'm going to share with you everything that he said in full context, but he seems to think pretty strongly that there's never going to be a Ripple test. It's always just the Howey test, and he shares his reasons why. And so I always want to be clear when I challenge somebody's ideas. I am just challenging the idea. I think that Stefan Huber provides all sorts of interesting information for the XRP community. I follow him, he follows me, so just in the off chance anybody might think that this is some sort of attack, it absolutely is not. I think it's fun to talk about this stuff, and I actually am the type that enjoys debates. Not arguments, but because the difference between argument and debate, that's when it gets rude and nasty. A debate is fun though, just sharing ideas and mentally, well, just like that. I guess just like I said, I guess that's sufficient. Kind of just mentally challenging one another effectively from an intellectual perspective. But anyway, so I came across this this thread thanks to XRP community member Pompous Maxi. So I just wanted, because he tagged me there, I just wanted to give a shout out and credit because this is what got me going in this direction. I think it's a fun topic of conversation. But before sharing additional thoughts and really breaking this down, I want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so I'm going to share Stefan Huber's perspective first, and then I'm going to share with you what I tweeted and my additional thoughts on this. And so here is what Stefan Huber wrote. All these Ripple test noise makes no sense to me by any stretch of the imagination, purely from a legislative legal point of view. If SCOTUS, that's of course Supreme Court of the United States, were to decide the Ripple case, it would still do so on the basis of the Securities and Exchange Act and the Howey test, and perhaps conclude in the best case that there is no binding contract to apply Howey. But that would not be a Ripple test, but simply an application of Howey on digital assets. The Howey test itself only exists because of then new Securities and Exchange Act. The Howey case made this new law workable in a concrete example. If there is no new law, then there will be no Ripple test, but simply the application of the 100-year-old Securities and Exchange Act to XRP. There would only be a Ripple test if a new law was written, and the Ripple/XRP case was the precedent case against which this new law would be interpreted in the future. Going to the Supreme Court of the United States with today's laws does nothing more than reinforce a 100-year-old law and test. A SCOTUS ruling on Ripple would not generate a new test nor create new law. It would be a purely administrative act to judge this specific case on the basis of 100-year-old laws. Without new laws, no Ripple test. Okay, so doesn't sound wacky at all. I just respectfully disagree. And I'm going to articulate why. And to kick this off, I'm going to share with you what I wrote, and then I'm going to expand upon this. I wrote to him in response to all of that. I think the point is that the SEC is trying novel theories against Ripple as well as other entities in lawsuits. So let me just pause right there and expand upon that even. So this idea of novel theories, mean, if you've been following the case, you know that the SEC, although if you ask them to their face, are you claiming XRPs is secure? Like, we never said that. But then if you look at their arguments are such that they are arguing that XRP itself is a security by the nature of it existing. And that's what is a common enterprise? I guess it's every single XRP transaction. Well, that's what the SEC is arguing. And it's so far outside of case precedent that it's unquestionably a novel theory that's not yet been tested in court. Now consider what led to the Howey test. It was the SEC versus W.J. Howey Co., the Supreme Court case back in 1946. The SEC ended up winning, but in that case, the SEC was testing what then was a novel theory. That's why it's such a big case law. It was a novel theory. Sometimes novel theories are tested and they're booted. Sometimes novel theories, which have never been tested, are tested up to the level of the Supreme Court and they're adopted. In this case, they were adopted. Okay, so that's an important thing to understand. And then, so again, after noting that the SEC's trying novel theories against Ripple, as well as other entities and other lawsuits, I wrote, a SCOTUS outcome could provide legal clarity for crypto markets at large, set it as law, and then the SEC couldn't try the novel theories again. So I'll pause to note, if this gets to the level of the Supreme Court, which I'm not convinced will happen, and kind of in a way hope doesn't, just because it would drag out for years and years, and then XRP holders are, continue to live in purgatory / be harmed for that whole time period, maybe miss out on another bull run. In that sense, I'm like, I kind of hope it doesn't happen, but it would provide supreme clarity and be awesome for XRP afterwards if we get a positive ruling on that. But again here, if that happened, and if the SEC's novel theory in that regard were tested, in the Ripple case at a Supreme Court level, if they lose, that would be new law. It would be broken down, and I'm going to show you the actual final determination, Howey, the actual text from 1946 in just a minute, and break down some things so you understand my points further. But it would be new law. It absolutely would be at that point. It would be a Ripple test. Okay, and so I then wrote, my understanding is that the 1946 SCOTUS ruling is informally known as the Howey test. Correct me if wrong. So let me pause right there. As I was writing, I can't remember if I was on my laptop or my phone, but I was just blasting off something really quick, and I felt about 100% sure I was correct that there's no technical from the Supreme Court thing called a Howey test. I was about 100% sure, but I was just like, I'm on the internet. I'm just going to type this as a hedge my comment just in case I'm wrong. But I was pretty confident, and I was right. There is no actual Howey test. There's something that's informally known as the Howey test, which is the ruling from the Supreme Court of the United States. That's what it actually is. It's just informally known as that, and it's broken down. The Howey test isn't the entire ruling even. It's just the prongs that we've come to know them as that are relevant anyway. And so I then wrote, so if we get a Supreme Court ruling with the Ripple lawsuit, people in the general population may call that the Ripple test, in which case it is just known as that. And so what I'm pointing out here is there is no legal designation. That was my understanding when writing the tweet, and then I verified later on, and I am correct in that. So if whatever happens in the SEC v. Ripple case, should it make it to SCOTUS, if it makes it to that level, whatever happens, people may call the outcome the Ripple test. Because it will be, and there could be, and likely would be, new law set. That's kind of the purpose of this, of going to the Supreme Court. So there would be new law. And then it would just be known as whatever people call it. So if people informally start calling it the Ripple test, and that takes off, then you got a Ripple test. That's it. It doesn't mean that Howey ceases to exist. It can be separate. It can absolutely be separate from the Howey test. You can apply, because that's the thing, like Howey, it's clear for legacy financial effectively, but there's uncertainty as it pertains to crypto. So you could have a separate test known as a Ripple test that's kind of an add-on to the Howey test that adds addition. It says, here's the law of the land. As it pertains to this, it's called the Ripple test now, effectively. Informally. Formally, it would just be the ruling from the Supreme Court of the United States. So that's what I was talking about. And then I shared this tweet from Stuart Alderati, Ripple's chief legal officer. He tweeted this December 21st, 2020. This is when we found out that the SEC was going after Ripple. The formal papers were filed, the actual original complaint filed the next day, December 22nd of 2020. But on December 21st of 2020, the day we found out about all this, Stuart Alderati tweeted the following. In 2015, the United States government concluded XRP was a virtual currency. Last I checked, the SEC is still part of the US government. Here's the plus side. The industry will finally get the clarity it deserves. Goodbye Howey test. Hello Ripple test. And so, look, I don't think the Howey test necessarily would go away, but it's possible. It actually is. Only in the, not that it ceases to exist in terms, like it happened in 1946, but it could be this amalgamation of various rulings that come to be known as that. So Howey could be incorporated into it, and we could be like, here's informally what we call the Ripple test, which also incorporates everything that was previously known as the Howey test. So again, what I'm saying is it gets messy because it's more like informally, what do humans call it in the English language? That's what we're arguing. It's like semantics, basically. That's what we're actually arguing. It is what it is from a legal perspective, no matter what we call it. But if we want to argue about what we're calling it, well, let's just recognize what we're doing is we're arguing about a definition that is informal. That's pretty much it. And so to drive the point home further, there are many websites that have the 1946 ruling, okay? And here you can see, this one happened to be from Cornell. But if you look at the top here, I searched for Howey test. It doesn't exist in here because the Supreme Court didn't write anything about a Howey test. There is literally nothing in here about a Howey test. And I have a separate tab open where I searched for common enterprise. Now, common enterprise, you know that's a prong of the Howey test, but it's not listed in, here's prong 1, 2, 3, 4. There are 4 instances where common enterprise was noted, and I'm scrolling up and down so you can see them. This was never written out as a list. It wasn't written out as a Howey test or a list. It's just there's one of the things that this is the law of the land now. The Supreme Court said so. That's it. Then you have another one. This you can see I use Control F to search for expectation of profit, and what they actually technically wrote was expectation of substantial profits. But there's a prong of the Howey test. But again, it's not listed out. They just said, here's why we came to the conclusion we did. This, and of course, it's now law. So if you look at the key points that make it the law and then put them in list form, that's called the Howey test. You can do the same thing with the Supreme Court ruling in the SEC v. Ripple case. You absolutely can do that. And if there's whatever the ruling is, whether it's for or against Ripple, it still could be called that. Now, hopefully it would be in favor of Ripple, and you could call that the Ripple test. Yeah, and here's another one, efforts of, because, the efforts of others, there's another prong. I searched for that, and there are 3 instances of it on your screen here. And again, they're not listed out. So if we get a Ripple test, it would look something like this. There would be all of the rationale for the conclusions that the individual justices come to, and then somebody after that would informally be like, here, I'm just summing up what the justices wrote, the conclusion, Ripple 1, here are the key things that determine whether or not a cryptocurrency is a security. I'm just making up how it might be worded like that. And then it would be in a list form. That's the Ripple test. There you go. So the idea from Stefan Huber, I just respectfully disagree. The idea that there wouldn't be a Ripple test if this makes it to the Supreme Court, I think that's flatly incorrect. So respectfully disagree. And if you think I'm wrong, well, you just get out. No, I'm kidding. If you think I'm wrong, that's fine. But articulate why I'm wrong. Tell me why I'm wrong. Use your persuasion to make me understand why I'm wrong, just like I'm trying to be persuasive here, because I do think I'm right, but I'm always willing to be persuaded if you have a compelling argument, because I just want to believe whatever's true, but I think I'm right here. So if I'm not, just let me know. I think debate's fun, so you're not going to offend me. I like my ideas to be challenged as long as it's coming from a good place and not a rude place. Then it's awesome. But I'll go ahead and wrap up here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.